let us deal with the question about love and illegally acquired evidence in a love circle. Private investigators are all over in love circles. Have you installed a gadget on your wife or your husband's phone? Every time they are talking with a secret lover, you have the information. I think over 80% of spouses have bought a gadget quietly. Have you gone to the Airbnb, paid that waiter to get you the booking where your wife went with the boyfriend to sleep? People have diaries. Personal diaries, they indicate their old day itinerary. You have no rights. Your wife has gone to the washroom, or your husband has gone to the washroom. You snatch the phone, take screenshots, and disappear with them. That is illegal. That can't be used as evidence before a court of law. Do you want to go nuts? Why do you want to know what can hurt your health? What you don't know can never hurt you. People are sleeping with a phone, your pillow, because they fear the wife or the husband will access that phone. Why should you be going with your phone to the washroom? All those evidence that is stolen is not admissible in court. Welcome to Court Helicopter Explainer. We are very happy to bring this explainer to you and resolve the many myths that people think about which are not true. There are 4 issues. Have you ever snooped into your girlfriend's phone or your boyfriend's phone and got some information from there without his or her consent? 2, have you installed secret CCTV cameras to monitor your boyfriend, your girlfriend, your husband, or your wife without knowing? 3, have you put CCTV voice recorders in your girlfriend or wife's car, or in your boyfriend or husband's car, so that whatever conversation is in the car, you get it? 4, have you put a tracker in their car so that wherever he or she is, you are able to track and know where he is drinking, you know which Airbnb they have gone with his boyfriend, you are able to monitor that person? Have you ever put on emails? All these gadgets. The digital era is with us here. Have you ever hired a private investigator whenever your spouse goes for a workshop in Mombasa? You send a private investigator following that person and capturing all the photos and videos of that person, wherever that person is, so that in real time, you are told she's now sitting with Wakili Dansen Omari in this place. This is a very serious issue. Almost 80% of the marriages are being dissolved because of cheating. Almost every ground being brought into the court is that I had this information. But the question is, will the court take that information without looking at it? We have had a serious discussion the last 2 weeks of the CCTV footage that was installed at Utumishi Academy. And some opinions are saying the CCTV helped to get that who are the girls who banned the others. Others are saying illegally acquired evidence cannot sustain in a court of law. Let us not waste time. Let us deal with the question about love and illegally acquired evidence in a love circle. This is the question that went before Justice Commissioner of JSC, Justice Murima, Anthony Murima, in petition number E406 of 2020, RC versus KKR. The brief facts of this matter is that a divorce was registered in a magistrate's court, that is divorce court number 672 of 2019, and also a Milimani children's case. We will not mention the children's case number because the law does not allow us. In the divorce cause, the respondent, who is KKR, fronted two grounds to support the cause. One, they are adultery and cruelty by the petitioner. To prove his case, he availed before the trial court voluminous bundle of documents derived from emails, audio, video, recording, transcripts, flash drive, data, photographs, mobile phone messages, WhatsApp text messages, CCTV footages, and social media conversations, all belonging and or having a bearing on the goings on in their life with the wife, that is the petitioner. Get what this man provided. Number one, he gave emails. 2, audio recordings. 3, video recording. 4, video transcripts. 5, flash drive. 6, data. 7, photographs. 8, mobile phone messages. 9, WhatsApp text messages. 10, CCTV footages. 11, social media conversations of his wife. Wow. This one was a really man. He had prepared by all means to get evidence, and he got the evidence. He says the petitioner is the second highest ranking officer in an arm of government. Justice Mwilu is the second highest judge as a deputy CJ in an arm of government called the judiciary. The DCI obtained access to her accounts on the basis of a misrepresentation by using a court order that was not obtained in respect of her accounts. There is thus demonstrated a clear violation of the petitioner's right to privacy guaranteed under Article 31. To countenance such conduct with respect to a person of the rank of a petitioner must beg the question, how do the rights of ordinary citizens fare? If the DCI can access into the personal accounts of the DCJ, what of small people like Vivian? What of Shelton? What of Bramwell? What of Cyrus? That is what this question the judge is asking. The court said, in our view, the conduct of the DCI in this respect was so egregious and objectively unreasonable and deliberate that to allow a reliance on any evidence obtained as a result could be detrimental to the administration of justice. So, the judges threw out the evidence against Justice Mwilu. Now let us deal with this evidence, this divorce matter. In paragraph 130, Justice Murima says, the petitioner, that is the husband, admits to the installation of a CCTV system in their matrimonial home. She, however, clarifies that the cameras were mounted at the gate, in the living room, at the TV room, in the dining room, and in the master bedroom, which is currently and exclusively occupied by the man. This is the woman admitting. She moves on further, clarifies that there was never any installation of a camera in their son's bedroom, which room she currently occupies. She contends that when she differed with the husband and was thrown out of the master bedroom, she occupied her son's bedroom. It is when the husband secretly installed a camera in the room. These people had put cameras, CCTV cameras all over, but they never put a camera in the bedroom of the young boy. When they differed, the wife ran away, like most wives, to the son's bedroom. In the son's bedroom, the husband came secretly and installed a camera that the wife was not aware that there is a camera. Paragraph 133. Therefore, the conduct of secretly mounting CCTV cameras and recording devices in order to record another person's private conversation and movements, unless legally permissible, is not only uncouth, but at least expected in this constitutional dispensation. Such amounts to an outright infringement of one's privacy and dignity. So the judge is saying the fact that the husband installed a camera, CCTV camera, secretly, it is uncouth and unconstitutional under the dispensation that we have today. Number two, there is, however, an issue of fitting of the vehicle, which was in the use of the petitioner with a tracking device and a voice recorder. She was unaware of the further installation of a voice recorder in the car. The petitioner, as the wife, contends that as a wife to the respondent and a co-director in their family company, she is well aware that the tracking devices fitted in their personal vehicles or company vehicles do not have any voice recording devices. Most vehicles have tracking gadgets to avoid in case the car is stolen or kidnapped. But a voice recorder, the wife was not aware. So any gossip, anything she was talking, anytime she was calling her friends, the recorder was recording. The judge in paragraph 141 says, I now find that the secret installation of the voice recorder in the vehicle usually used by the petitioner was a violation of the petitioner's right to privacy. Paragraph 142, the judge looks at email accounts and social media accounts. And the judge in paragraph 143 says, by accessing the petitioner's personal data in her accounts, the respondent overstepped the conditional right of access. The judge proceeded and gave these issues. Now, listen to what the judge said. I know you do that. You have recorded your girlfriend. You have recorded your boyfriend. You have recorded your wife. You have recorded your husband. What is it illegal? Court helicopter will always bring you what the courts have declared to be illegal. In paragraph 161, the recording of the petitioner and the respondent conversation having regard to the provisions of Article 31D of the Constitution is production violates the petitioner's right to privacy. So the judge makes a finding. Any recording of somebody without his or her consent is illegal. 2, taking school diary photos and pictures while in school is not illegal. The judge found out that by virtue of the photos being taken in a public school, there's nothing illegal there. Then he moves on to say, paragraph 162, recording of conversations between the petitioner in the presence of the respondent, 1 Rohan and Esther, which the respondent in the recording, among other things, admits as being a good father to the extent that it contains communication in respect of the petitioner, it violates her right to not to have her communication infringed. Whether the information you are recording is positive information, like this communication, somebody was telling the man, you are a good father, but there was no consent. You are a good mother, there was no consent. You are a beautiful lady, but there was no consent. Whether the message is positive, recording somebody, there must be a consent. It moves on to Southern. Recording the petitioner's conversation about an alleged abortion she had, its admission to evidence violates the petitioner's right to have private communication. This lady had at one time talked that she had a pregnancy and she aborted. This was private communication. It might look bad. It might look a serious admission in marriage that your wife is admitting that she has had an abortion with another, by conception with another man. But that, if she never gave consent, that is illegal. Next, the judge says, any telephone conversation of the wife with an alleged lover of hers named Ron, that is contrary to Article 31D, Article 54 of the Constitution. So have you ever recorded have you installed a gadget on your wife or your husband's phone? Every time they are talking with a secret lover, you have the information. I think over 80% of spouses have bought a gadget quietly. Vivian did a research and told me that at night when husbands sleep, wakingorota, wamesahau na wamekunya Guinness yao after watching the World Cup, the wife takes the phone, has a gadget, installs it in your phone. Boss, any communication, any message, you send and delete, the message goes to your spouse. This Justice Murinama found that is an illegal act. Any transcript of a telephone conversation between the petitioner and a person called that one, the same, is not allowed. It is illegal and it cannot be admitted. The judge moves on to say in paragraph 165, any evidence relating to the petitioner's conversation with her son and another one with her alleged lover, in view of the manner in which the evidence was procured, violates the rights of the petitioner for privacy. He moves on to say, any recordings and information of the petitioner's private conversation and her alleged lover's biodata, their admission will violate her rights under Article 31 and Article 54 of the Constitution. Paragraph 168. Are medical reports. This is very controversial. They are marked KKRS 031. These are medical reports. The woman does not indicate, the man does not indicate where they were obtained from. It also cannot be discerned from the respondent's supplementary affidavit how he got them. The respondent had the burden of demonstrating how the reports came into his possession. Since there is no indication to that, that evidence is inadmissible. So, any medical reports that are not yours, you are not supposed to have them, whether that's your wife's medical reports, whether that is your husband's medical reports. He moves on to say in paragraph 171, these are purchase receipts for airline bookings, tickets, and hotel receipts of the petitioner, the wife. They were procured from the petitioner's private custody. Given in the manner which they were procured, the evidence is inadmissible. Have you gone to the Airbnb, paid that waiter to get you the booking where your wife went with the boyfriend to sleep? Have you gone to KQ, to Jumbo Jet, to airlines and gotten air tickets, and you tell the wife or you tell your husband, I have the ticket, you are in Hawaii? He moves on to say, in paragraph 172, any personal diary entries that do not entitle the respondent access to without consent of the petitioner, that is inadmissible. People have diaries. Personal diaries, they indicate their old day itinerary. You have no rights. I know quite a number of us men are tempted to open the woman's bag, steal that diary, steal that phone, check what is there. The court has found you cannot interfere with a personal diary or details of a personal diary. The judge moves on to say, in paragraph 173, screenshots of the petitioner's personal communication. Your wife has gone to the washroom, or your husband has gone to the washroom. You snatch the phone, take screenshots, and disappear with them. That is illegal. That can't be used as evidence before a court of law. What did the judge say in the landmark decision by Commissioner Justice Anthony Buriba? A declaration hereby issues that the respondent's actions of secretly installing a CCTV camera in the party's son's bedroom, which room the petitioner currently occupies, the respondent's actions of secretly and variously installing voice recorders with a view to record the petitioner's private conversation. 3, the respondent's action of secretly using a private investigator. Lastly, and the respondent's actions of accessing the petitioner's email and social media platform accounts without the consent of the petitioner, all offend Article 28, 31, and 54 of the Constitution. The case, the evidence that was going to be adduced in the divorce proceedings were declared illegally acquired, not admissible, and therefore you cannot use the address. What is the import of this matter? 1, many people have information, they cannot cope with it. You get into the phone of your spouse and you find your best friend or your brother or your sister is the one they are cheating with your wife or your husband. You go nuts. Do you want to go nuts? Why do you want to know what can hurt your health? What you don't know can never hurt you. Number 2, anytime you go to bed, stop sleeping halfway with a view of stealing somebody's phone. People are sleeping with a phone, your pillow, because they fear the wife or the husband will access that phone. Why should you be going with your phone to the washroom? You can't leave it behind, because that evidence, now we have brought it to you. All those evidence that is stolen is not admissible in court. When now you are seated in a bar, in a cafeteria, in a city, in an open space, don't be worried about the person recording you. Private investigators are all over in love circles. That cannot be a ground for divorce. That is evidence inadmissible. You now know what evidence is admissible. Wakili Dan Sanomare, we thank Vivian and his new partner Sheldon who have done this research and they have brought it to us. You have it. We keep you bringing you blockbusters from the courts and from the law, statutes and constitutional provisions. Asanteni.